I think, Josefa, what we also need to discuss, and again, really crucial when it comes to India and also unique from an Indian perspective, dispute resolution, right?
Very
It's
important.
very important. And I guess every foreign company's biggest fear, they don't want to end up caught, running around Indian courts for dozens of years. So, how do we deal with those kinds of issues?
Sure. So I think before we move on to dispute resolution and enforcement of cross-border awards and judgments, one point I wanted to touch base upon, which is extremely relevant from a technology collaboration perspective, is when a foreign counterpart is giving its technology to the Indian company or to the Indian provider, or when the foreign counterpart is rendering some technical services or sharing some know-how, there is usually a payment involved in such situations, which means that the Indian counterpart needs to pay some monies to the foreign counterpart for providing such technology or such services. From a cross border perspective, such payments are usually in the form of license fees or in the nature of fees for technical services or maintenance services or service fees. There are various names given, but there is some fee which is remitted outside India. From a exchange control perspective, Indian exchange control perspective, the coin terms for such payments is either royalty or fees for technical services. I wanted to share this with the participants on this webinar, that historically there were certain thresholds or certain caps on remittances by the Indian company or the Indian entities for payments in relation to availing the foreign technology or foreign services. That is, the payments which were made from India uh, to abroad or to these foreign companies. There was a certain cap. It was 5% in some cases, and there was another 8% cap in some cases. However, with India moving on to a more liberalized regime, these caps have been removed. So as of now, the way the law stands, that Indian companies can make payments when foreign companies share their technology to them under the automatic route, that is without any government approval and without any caps. But Shreya and Ruchi, one thing which our foreign friends and foreign clients need to be mindful of, that these payments which are made by the Indian companies need to be reasonable. They can't be excessive in nature. So it means that if the Indian company's turnover is say $5 million, you can't remit $4.5 million in the nature of royalty and fees for technical services. That may raise issues with the regulators, and that may not amount to good trade practices.
And from the tax authorities as well, although that's something that we'll talk about in a bit.
Sure.
But if I recall right, one of the reasons you mentioned this cap that the regulators may impose is because we found several companies were using the royalty route as a way to extract cash out of India, both from a tax perspective and from a cash accumulation at the India level perspective. But we can touch upon that when we deal with tax.
Sure. And in fact, just to conclude that line of thought, that there have been news reports, and the Indian government is considering of bringing back these caps, because as you rightly pointed out, there have been instances where the foreign collaborator is actually draining the Indian company, and whereby causing an adverse effect to the Indian shareholders. So
I see.
just to conclude, currently there is no cap, but in the months to come or in the weeks to come, there is a potential, a possibility that the government brings in some of these caps back.
So, dispute resolution.
I don't think anybody likes to talk about this. Nobody wants to fight. Everybody wants to have a great business relationship. But dispute resolution is an extremely interesting topic. Historically, in any cross-border agreements, usually dispute resolution clauses were cookie cutter or template clauses, which specify that if there is a dispute, the parties would amicably try and resolve it. If they don't resolve it, there would be a certain court which would have jurisdiction, and that was the end of it. But having said that, jurisprudence on this, especially on the India front, has evolved enormously. India is a party to the New York Convention, which means that foreign arbitral awards which are passed outside India can be enforced in India based on the principles of reciprocity under the New York Convention. However, interestingly, under its domestic law, what India has done is gone one step further. What it says is that arbitral awards can be enforced in India on two grounds. One, the party needs to be a country to the New York Convention. Second, that country needs to be notified as a reciprocating territory in India, which means that if a certain country is not a reciprocating country or it's not notified by India as a reciprocating country, arbitral awards from that country cannot be enforced in India. The same thing is applicable for court awards. New York Convention doesn't apply, but for any foreign court judgments to be enforced in India, uh, that territory from where the court judgments are being passed, it needs to be notified as a reciprocating territory in India. So I'll give you an example, Shreya. There is a cross-border contract where the company is based in a EU member state. Let's take Germany for example.
Okay.
And the German company is sharing some amount of technology with the Indian company. It's a classic technology collaboration where the agreement is governed by X law, and the dispute resolution under that agreement says that if there's any dispute, the courts at Germany will have jurisdiction, and the courts at Germany will resolve such a dispute. So actually there happens to be a dispute, and the Indian counterpart is held liable, and there are certain damages which are passed by the Indian counterpart by the German court. Typically what would happen is the German counterpart would take the court judgment of the German court and come to India to enforce it against the Indian party. The catch out here is Germany is not a reciprocating country which is notified for the purposes of court judgments. Hence, the judgment which is passed by that court in Germany would not be enforced as if it is passed by an Indian court, which means that the German counterpart has probably lost all its rights and remedies there and there. While the same does not apply for arbitration, which means that if the dispute resolution clause in the agreement was such whereby the dispute was to be resolved by arbitration, which was to be held in Germany, and once the arbitral award was passed in Germany, it can be enforced in India against the Indian counterpart as if it's an Indian arbitral award. The reason being that Germany is recognized as a reciprocating territory for the purposes of arbitral awards. So, these are the finer nuances, and this goes back to the fundamentals of principles of reciprocity, which we need to be extremely careful when we are drafting the dispute resolution clause and choosing whether we are going to go in for arbitration or we are going to go in for a court process, which are the courts we are going to agree on. If we're going for arbitration, what is going to be the seat and venue of arbitration. So all of these things need to be very carefully thought of.
I see.
The most and the last point on this on the dispute resolution front is interim reliefs. Now these become extremely critical when there is a technology collaboration. The reason being twofold. One, if there is a breach by the Indian counterpart to have a final resolution made under arbitration or a court process may be time consuming. However, the foreign counterpart would want to seek an interim injunction at least against the Indian counterparty, stopping him from violating further IP breaches or confidentiality breaches. The Indian jurisprudence, the way it has evolved in the recent past due to a landmark judgment by the highest court of the land in India, which is the Supreme Court, it says that if the seat of arbitration, if there is a cross-border contract, that is taking the same example between a German company and an Indian company, a cross-border contract, where the parties have agreed to arbitration as a dispute resolution mechanism, but the seat of arbitration is outside India. So assume it is Germany, the seat of arbitration. Indian courts would not pass any interim reliefs in such situations. The reason being that the stance which has been taken based on the recent judicial precedents is that if the parties have chosen a venue for arbitration outside India, then Indian courts would not want to interfere even for the perspective of interim reliefs. interim reliefs would only be granted by Indian courts even in a cross-border situation is when the seat of arbitration is in India. So, coming back to the point, Shreya, that whenever we are drafting any dispute resolution clause in any technology collaboration agreement or a technology transfer agreement, it is sacrosanct that we think through all of these permutations, combinations, and depending upon the business as well as the commercial needs, we bring in the relevant clauses. I think Ruchi also wanted to make a comment. So go ahead, Ruchi.
Yeah, Vijay, I wanted to ask you to touch on a point, especially with respect to protection of intellectual property. We are often faced with this question from European companies, in terms of India as a regime for intellectual property. It would be good if you can say in terms of how the courts react for enforcement of intellectual property rights in case of any IP breach or infringement.
No, Ruchi, in fact, that's a very good point which you have raised, and probably we should have touched base upon this earlier. Indian courts and Indian authorities are very forthcoming when it comes to protecting intellectual properties. Reliefs in the forms of injunctions are granted pretty quickly. It's not like a normal court process, so you can get an injunction within a month's time. Even in terms of certain orders which are given by courts, that's pretty quick. Even the enforcement arm, which is the police, which helps in investigating certain sort of breaches, is also quite helpful. So broadly, if I can say, Ruchi, the enforcement as well as the judiciary when it comes to intellectual property in India is pretty robust. It has greatly improved, and what was there probably a decade ago, which was lacking on certain aspects, is no longer there. But we still have a certain improvement to make, which I'm sure in the coming months and years it would get more and more robust. But having said that, the arm is pretty strong, and foreign counterparts can be assured that if there are breaches on the intellectual property, or if there is some sort of piracy or theft on that front, there is a mechanism which they can always avail of and protect the intellectual property.
Yes. So, hearing from you, what we can gauge is that there is improved commitment by the government when it is pushing for initiatives like Make in India. At the same time, it is providing good commitment to international investors for protection of intellectual property regime by, of course, having a good legislation, but at the same time providing good administration, IP administration and infrastructure for intellectual property registration, etc.
That's correct. So I think we've dealt with dispute resolution.